Hi, my name is Leon Snaid and I'm a certified immigration law specialist certified by the State Bar of California's Board of Legal Specialization. Now, the United States has treaties of trade and navigation and commerce with various countries that allow citizens and nationals of those countries to come to the United States, make a substantial investment in a business, and to direct and develop that business. Well, it's got to be a trading and operating business. You cannot come in and make a substantial investment in a property, a house, or a small building that doesn't really require management or executive decisions. The requirement for a substantial investment is not defined as a money amount, so you will not find anywhere in the rules or the regulations or the law a specific amount that will qualify as a substantial investment. But let me give you two examples. Let's say we're talking about a business that requires machinery, equipment, inventory, like a restaurant will have freezers and stoves and slices and dices, tables and chairs, etc. That kind of business would require a larger investment than, let's say, a service investment, that a service type business that really may just require computers and printers and fax machines, where the person's labor is the essence of the business. What kind of amounts are we talking about? For a service type business, you're probably looking in the range of about $50,000. And then if it's a business with machinery, equipment and inventory, the amount would be significantly larger. The investor from a treaty country does not have to own 100% of the business. He or she can buy a 50% share in the business as long as he or she has control over the business. When it comes to starting a business, it is necessary to invest the money and then go and ask for the visa. So it's not a matter of just sending money to the United States, putting it in a banking account where you've got total and complete control over the money, and then asking for the visa. The State Department and the Immigration Service want to see that it's committed to the business. Now, one of the ways that this can be done is, let's say, for example, you buy a business. You can buy the business on condition that you get the E-2 visa. How would this be done? Well, the seller would put documents into an escrow or an attorney's trust account that reflect the ownership of the business. That's what the seller puts in there. The buyer would put the money in for the purchase price into the escrow or the attorney's trust account. The agreement would be that the purchaser be able to get an E-2 visa within a certain amount of time. Well, the purchaser no longer has control over the money, and if he or she gets the visa, well, then at that time the money is released to the seller and the seller's ownership documents are released to the purchaser. Well, money is the most obvious one, but you could bring machinery to the United States, or equipment, or inventory, and there are different ways in which you can show that you are investing in the business and the investment has already been made. You cannot, for example, borrow money to buy the business and then secure the loan from the bank with the assets of the business. The assets of the business must be free and clear. So it's important to realize that you're first investing and then you are asking for the visa. So one of the important things that the consul wants to see is that you have a 5-year business plan. He or she wants to see how you intend growing the business. And they want to see that this investment is not just going to make you a lot of money and you or your wife. They want to see that it's going to benefit the United States. It's going to provide working opportunities. So in your business plan, you would reflect how you see your staff levels increasing over the years. Even if your wife and children are not of a country that has a treaty agreement with the United States, they will be allowed to accompany you into the United States, and your spouse will be able to apply for work authorization, and that work authorization may be to work in the same business as you're running or in some other business. The children under the age of 21 will not get work authorization, and this visa is only valid to them until they turn 21. They would have to have their own basis for remaining on in the country, like let's say they became students. Now, one of the strange things about the E-2 visa is that, unlike many other visas which have a maximum stay in the United States, the E-2 visa can be extended as long as the person is running the business, it's viable, and this can go on for many years. It is not permanent residence, and as soon as the investor stops running the business, he or she must leave the country. Well, if you go to my website, www.snaid.com, and you click on working visas and then click on E-2 investor visas, you will get a list of the current countries. Obviously, you can also find that on Google. I hope this information has been valuable to you, and if you have any other questions, please call me. Thank you very much.